Good evening. Hello, we are live tonight. It is Wednesday night, June 29th, 2022, almost 8 p.m. Eastern Time. We are going to go live. We're already live. We're going to be answering questions. And we're going to be talking about the latest in immigration news. What's really going on with this immigration? So say hi in the comment. Let me know if you're here. Say hi in the comment. I see Kelvin, Oki. Yeah. Say hi in the comment if you're here. We are going to be talking about the latest in immigration news. Say hi in the comments so we can get started. Hi, hi, hi. Hi, Modesta. Hi, Rosemary. Uh, yes, we're going to get started. Hi, Kelvin. Thank you for joining me. I know it's almost 8 p.m. I'm gonna go fast. We are going. Hi, Buleu Lukengo. Hi, how are you? I hope you are doing so well. And we're just gonna be talking about the latest in immigration news. What's really happening is that. Hi, Nana. Hi, so let me just get started. So we have two subjects, okay, and then I'll take questions. But the first subject, we are going to talk about prosecutorial discretion and what happened with this memo, Majorca memo. Remember back in April, I was here talking about prosecutorial discretion, the power of the government to drop a case. And a lot of people filed for it, get dismissal, administrative closures, case got terminated. But because of the lawsuit in basically in Texas. Remember, things always happen in Texas. Well, because of that, they have put a stop on that late memo. Meaning what? Meaning that prosecutorial discretion is still going to be going on, but it's going to be at their own discretion, not like the way we have to file for it. So now ICE is just going to look at the case. If they want to dismiss it, they will. If they don't want to dismiss it, they won't, because of the way the judge in Texas ruled. Remember, the judge in Texas ruled that the executive does not have the power to decide who get deported and who does not get deported. They cannot just pick and choose. So they just have to go with what the law says, not what the Biden executive order says. And because there's no stay of order, pretty much there's no appeal right now. So that's why that Majorca memo got vacated. So pretty much, yeah, the latest memo, we can't go base of it and try to decide whether we're going to file prosecutorial discretion or not, because it's no longer taking into account, basically, so to speak. But prosecutorial discretion is still going to be going on the way it was back under Obama. Really, not the way it was under Trump, but the way it was under Obama. Really, they look at the case and see, well, will they dismiss this case? Yes or no? Stuff like that. So, hi, Sam Kamau. Hi, Sam. Is it Dorcas? Kamal. Okay. Anyway, so that's what's going on with prosecutorial discretion. And then we have this 10 years and 3 years bar. I am going to explain it because a lot of people are getting confused. Okay. Am I eligible? Does it apply to me or not? So let me share the screen so we can discuss it. Unlawful presence and how does unlawful presence get triggered, and why USCIS is changing its interpretation as to certain applicants only. Not everybody's qualified for this type of relief, but certain applicant only. Okay. Let me share the screen, then we can go and talk about it. Okay, unlawful presence and inadmissibility. So the way it gets triggered, right? If you stay in the United States and then you accrue unlawful presence for more than 6 months, less than a year, and once you leave, you trigger the 3 years bar. So before you get here, you have to either apply for a waiver and wait for it to be granted in order for you to come back, or wait the 3 years. After the 3 years has passed, still after the 3 years has passed, you still have to tell them that in a waiver, and then apply and come back. If you stay longer than a year, then you get out of the United States after accruing a lawful presence for more than 1 year. When you get out, you're going to be banned for 10 years. Okay. That's how it works. So that's the general rule. Unless you apply for a waiver and then the waiver get granted, then you can come back, right? But in order to apply for a waiver, you have to have a qualifying relative. Really, if you're in the United States and you want to get out to go cancel processing, you have to have a parent or a spouse if for it to get that 601A approved. So if you're outside and then you can apply for extreme hardship, then sorry, parent, spouse, child, and remember they have to be either U.S. citizen or lawful permanent resident. That's how it works. But what happened was there was a case, Gomez versus USCIS. That's what happened. And now what they're saying is that, let's say, for example, sorry, let me put it a little bit bigger so you can see. Okay. So on June 24, 2020, USCIS published a new policy guidance in USCIS policy manual concerning the effect of returning to the United States during the statutory 3 years or 10 years period after departure or removal. So what basically, let's say, for example, if somebody was here and then they accrue unlawful presence either for 3 years or the trigger, either the trigger the 3 years bar or the 10 years bar. Then they leave, they go home. For some reason, they apply again and come back without USCIS, without the embassy checking whether they had a ban or not. But for some reason, they get a second entry, right, in the US. Now they apply for adjustment of status. Usually, they will get they will be required to apply for a waiver, or it's just going to get denied because they did not wait for the 3 years bar. But now USCIS is saying that if you had returned to the United States during the statutory 3 years or 10 years period, okay, you file your application with USCIS after the expiration of the statutory 3 years or 10 years bar, and USCIS denied the application on or after April 4th, 26, solely based on inadmissibility under this one, INA 212A 9B, which is unlawful presence, and then you return to the United States during the statutory 3 years or 10 years period, you should write. If your green card was denied, you should pretty much file a motion to appeal. But remember, motion to appeal, when it's late, it's basically getting denied because of untimely. But now, guess what? USCIS is accepting those untimely motions to reopen. Okay? And if you want to reopen it, then you have to write to identify what was the problem, return to the United States during 3 years or 10 years statutory period ban. Okay? And then you come back you apply for green card. If your green card was denied, then you can reopen it and reapply, because what they're doing is they are allowing that unlawful presence to run in the US, and they are not requiring a waiver. Okay, so specific cases only. Let me stop sharing and take questions. Yes, specific cases only, friends. Specific cases only. So now I'm taking questions. Do you have questions? I can re-explain again, but do you have questions? If you have a question, please, I'll just put it right here so we can answer those questions. Hi, Mwana Congo. Please put your questions so we can answer them. If not, then we're just gonna end this live because I came here to take questions. That's the purpose of it. Yeah, I'm just gonna reiterate again, okay? Two major subjects going on, or two major news going on. The judge in Texas pretty much made a stop on prosecutorial discretion as far as the latest memo is concerned, right? Remember back in April, Secretary of Homeland and Security issue a memo allowing people to request for prosecutorial discretion, whether you were a low priority or high priority. They even accepted high priority cases to be to add mitigating factors so that they can benefit from it. But the judge in Texas ruled against it, said that, well, it's not the power of the executive to decide who to deport or who not to deport. In other words, pretty much deportation is back, business with ICE is back as usual. But it doesn't mean that ICE can still, on their own, look at your case and decide whether they can use prosecutorial discretion or not. It just means that business deportation is back as usual. Whether you are low priority or high priority, it doesn't matter anymore. Okay, that's what it means when this judge in Texas pretty much blocked that. So the Mallorca memo has been vacated. That's one thing. That's the major news. The second news, that's good news for certain people. If you were banned for 3 years or 10 years, you left the country and came back during that statutory ban of 3 years or 10 years, and you apply for a green card and your green card was denied because of unlawful presence, and then they were asking you for a waiver. Right now, what they're saying is that you can reopen your case and you don't need a waiver for it, and reapply again for your adjustment of status. But it's very specific, must have been outside of the US and enter the US during that statutory ban period. Okay, so that's what's going on. Two major newses, but they always have a lot. Okay, let's get questions now. Kingo, I got two questions. Came to the US in 2015 as asylee, and my start is just a month ago. I want to know if once I got my green card, am I able to apply for the citizenship? Well, remember, citizenship, you have to count from the day you got your green card, 5 years, right? So for asylee, I believe they count from the day asylum was granted. If I don't mistaken, you need to do some research about it, but you're not going to apply automatically. Citizenship with residency, it's 5 years. If you're asylee, I believe it's going to be 4 years because they're going to be counting from the date asylum was granted. So if you count those days from the date asylum was granted to the day 5 years has passed, usually on your green card is going to backdate the date of residency. So, and then 5 years, then you can apply for US citizenship. not right away. Oh, the second question, how long is it going to take to get a green card? Well, what you have to do is look at case processing time. You look at your receipt. Usually, it will tell you at the bottom of your receipt, at the left inside corner. It's going to tell you what center your application went to, and then you go on USCIS.gov processing time, put your application, put the date. Boom! It's going to tell you exactly how long it's going to take you, so for you to get your green card. And sometimes too, you can just call them and tell them, ask them, what is your processing time? They'll tell you too. So yeah, this for that one, you can find out, you can really find out on USCIS.gov processing time, put your receipt, um, and based on where your application went, really it's gonna tell you approximately how long it's going to take you. So who else has a question? I don't think people have questions. This life came by surprise, right? Nobody was waiting for it. Modi Sisoko. Good job. Thank you. Well, I think nobody else have. If you don't have questions, well, until next time. If you don't have questions, if you find questions later, please don't forget to comment below, or you can join us on our Facebook private private Facebook group and post your question there as well. But you can always post your question in the comment below. I'll come back and look at them and then try my best to answer them. Yeah, if you need the consultation, again, you can call, email me. You know I charge for consultation. That's not a secret. So anyway, I guess you guys don't have more questions for today. I guess I'm done. Okay, until next time then. Bye-bye. Thanks for joining. Thanks. See you next time. Bye-bye.